the Chief Justice put together a forum, and the forum was on elections. And it was about the role of the judiciary in ensuring credible elections. But more importantly, when we have the elections and there are disputes and we send cases to the court, petition the court and their outcomes, how do we make sure that the various presidential kind of political party, other stakeholders tend to accept the outcome of those court decisions? But critically, do we even respect the judiciary at all in becoming the ombudsman or the referee when those disputes arise? I guess that's why we want to also put into perspective our discussion next, and it's with Samson Ladi Ayenini. He's a legal practitioner. He's also host of Newsfile on this very channel as well as on Joy FM. Thanks for joining me. He quickly has to go to the court. You know, he's in full regalia. but yesterday's forum, and I know you had a main discussion, and because it was premised based on
I did the main presentation, the main research work.
Tell me about
on the theme, and the theme was the Judiciary and Election 2016. Now, this is the annual Chief Justices Forum. It's an annual forum organized by the Judicial Service, particularly by the Chief Justice, and it is an event that allows the Chief Justice the opportunity to have persons other than those within the legal fraternity, judges and lawyers, to contribute, to brainstorm and contribute on to how to improve the processes of justice delivery. But this year's has been special and has been organized at this time for a good reason. And as you can see, the theme is the Judiciary and Election 2016. Now, I would want to say that it's good to give you a sneak peek of an overview of the emphasis by the various speakers. The Chief Justice herself, who opened the discussion. You have over 200 people attending, judges, all of them, all judges of the Supreme Court. You have Court of Appeal judges, you have High Court judges to the lowest. And then you have civil society persons, Dr. Emmanuel Kwete and the rest, civil society persons being brought in, chiefs, you have security, organizations also coming in because they all have a role to play. Traditional rulers all coming in. Now, when the Chief Justice spoke, she said, obviously, it does appear that we have an election coming up where even before we went to the polls to cast the ballots, cases are already coming up. Of course, we know that there are 12 presidential hopefuls who have been disqualified. We know that about 3 of them or 4 have so far put their foot in the court. We are sure of 2 who have already done and others who are threatening to do. Now, it does look like eventually all the 12 will be in the court. Then there is a potential that the mass disqualification that happened for presidential candidates may cascade to parliamentary candidates. What that means is you're going to have multiples of suits that are going to come up. Now, when they come, even though the judiciary did not create these problems, it ought to be prepared, because ensuring free, fair elections, a peaceful election, is a shared responsibility. So the Chief Justice said, look, having recognized or having anticipated this, what we have done, and so far you know that she has designated 17 courts, 5 in Accra only. Now, and has charged them to sit from 9 a.m. till 6 p.m. It doesn't happen. Normally by 1 o'clock, the courts are knocking off. And they are going to sit on weekends. In fact, they may have been asked, directed by the CJ, to sit on holidays as well, except that in 2013, after the election petition, Bernard Mona of the PNC went to the court and challenged CI 74, which was the rules for the conduct of presidential election petitions, which allowed the CJ to let the court sit on a holiday. And he went to tell the court that giving the Chief Justice the power to allow someone to work on a holiday is wrong. And somehow the Supreme Court agreed with him. So holidays have been struck out. So they are sitting all day, 9 a.m. to 6 p.m. and weekends, minus holidays. And they've been asked also to be expeditious in how they go about the cases. So that's what the CJ had to say, and say that on the basis of what she's done and what the event yesterday was going to come up with, she was assured that the fears, general fears, that December 7 is in danger may not happen. Okay, then you had Justice Jones Doshe, also of the Supreme Court, stepping to the podium and speaking to the politicians, some of whom were in there because they were also invited, that when the judiciary gives the decisions, you must be ready to accept them and accept in good faith. Be a good spokesperson. There's good reason for that, because if you don't accept, you can cause mayhem. And more particularly, in 1996, after the elections, there was a petition by George Isaac Amu of the Ayawaso West Wuogon constituency, challenging the validity, the results declared by the EC. The High Court took less than 3 months to deal with the case, and eventually he was the victor. But do you know what happened? The Rebecca Adote of the NDC then, who had been wrongly declared winner, went to the Court of Appeal. And that was an obvious technical approach to frustrate George Isaac Amu from enjoying the fruits of his victory. We all know
eventually what happened.
Exactly. So eventually, by 2000, when the life of that parliament had expired, the Court of Appeal was still adjourning that case, meaning it was useless to have gone to court. He won, but he never got to parliament. So he said, accept the results. And more importantly, judges must be bold that when people bring the suits, they should examine the suits and be clear in their mind that the suit is not frivolous, that the suit is not an attempt to use technicalities to frustrate or drag a certain process. And they would be able to throw out a case immediately.
All right.
Then the final one was by Dr. Bimpombuta. Dr. Bimpombuta also touched on very important issues.
Prominent legal practitioner.
He's a colossus when it comes to law reporting in this country. Now he steps to the podium and says, look, there are issues we need to deal with. Some of the cases don't even have to come to the courts. In 2010, this country passed a law. It's called the Alternative Dispute Resolution Act 2010. It allows us to be able to resolve some of our problems even before we got to the court. And that method is a way which is even a lot more speedy, okay? It gives you quick time to resolve issues. So he gave an example. The Ayi Mensah case, you remember? That assemblyman who was contesting and didn't get the opportunity to file or so, or was being disqualified in a way, he went to the Supreme Court. Why did he go to the Supreme Court? Because his lawyers had written to the EC not once, not twice, but about 3 times. They didn't get any good response. Meanwhile, on the face of the facts, the EC didn't have a good case. And yet, it sat there and waited till the suit came on. When that suit came on, the guy eventually won. And when he won, we know what happened. There was an injunction on the whole assembly elections. The country sank millions into that enterprise, and it went waste. So he used that as an example and say, why must we always be running to the court? We, all the players, and the EC boss was there.
Will the parties be willing to
They should
use
be willing.
ADR?
They should be willing. and
Did you get the commitment from them yesterday?
It was not to exact the commitment by way of anybody signing any documentation. And in my presentation, which was the presentation that was used to do the discussions, I clearly noted certain things which there was unanimity among all at the forum that it ought to be applied. Strict compliance with the rules. When lawyers are coming to court with some of these cases, the judges should insist and not allow them to delay the process by asking for adjournments and giving one excuse or the other. The lawyers must also cooperate. The judicial service officers who are threatening a strike must also cooperate and ensure that this process go on smoothly. And most importantly, when technicalities are being used to frustrate the process, the judges must insist that they will not allow some of these things. And these were agreed. So in the end, it is very obvious that we know Dr. Endum and Co. are in court. We know that even beyond that, there are other matters that are in court over CI 1994, which are supposed to be determined. That every effort must be made to ensure speedy trial of these matters. And the CJ used one example, which I'd like to end on. And that example is that a month ago, there was an election-related case. The judge was on holidays because everybody was on holiday as far as the justice system was concerned, almost all of us. The lawyers who were on break. The CJ ordered the judge, wherever she was during the holiday, Justice Mrs. Benasco-Esa, to return to the court and to deal with the matter and finish it before the EC's deadline of 29th and 30th for filing and accepting nominations. And that was the Kwesi Mintim MPP primaries. At that time, they didn't have a candidate. And somehow, coincidentally, I was in that case. I defended the man who is now the candidate for the MPP. Now, that matter...
Joe Mensah.
Yes, Joe Mensah. That matter was determined in 3 days. The matter was finished. Some of the lawyers have sought to ask for certain things which would have delayed the case. The judge said, hell no. I want it this way and you do it my way.
And that's the sort of posture the Chief Justice is...
The same thing.
Okay.
So within 2 weeks, we had judgment on the case. We finished the case today. We're asked to submit our arguments or addresses the next day, 2 p.m. You can't submit it by running to file and so on. So the judge says, I'm ready to receive your addresses by email. And I know you also need the record of proceedings to prepare your addresses. Do you know what I'll do for you? Go give your email addresses to the clerk. She'll forward everything to you by email. Speedy.
Well, Samson, by what the regulations are, you lawyers also, by using the rules and the Constitution, go by the technicalities because it's part of the profession and the way it works. How then do we tend to synchronize that with what the position of the Chief Justice is, which I think is more of an appeal than anything? It
is not an appeal, really. The Chief Justice has powers to direct her officers how to work. So these are specific orders and directions to them. You have no option. And you need to insist on these things. And you say rules, and you say lawyers love to, play on the technicalities. Yes, sometimes we do when it helps us. But this is the situation where December 7 cannot be negotiated. So any lawyer who has Ghana at heart must not go to the court and play games. If they go to play games, the judges will also use law and due process. The Supreme Court recently, in the clarity judgment he gave in the Abu Ramadan case, said, and with emphasis...
Which one? The one in May?
Yes, okay. With emphasis that technicalities should not be allowed to delay or frustrate a genuine case. So the judges are minded, and the Supreme Court decision is binding on everybody. In fact, in our, we have a law we call the Interpretations Act. It also says, do not allow for reliance on technicalities to frustrate a genuine situation. Well, elsewhere, they have put it in their constitution, but we haven't done that yet. So we can only rely on some of these things. And I think that so far, from the Kwesimetim example to the Papa Kwesi Ndum case, where Justice Chebafo also agreed and said you can file your processes through electronic process. You wanted the date for the process to be brought forward. I agree, let's bring it forward. That is an indication that there is going to be a swift dealing with the cases, but not in a way that compromises justice.
Our colleague Raymond Akwa spoke to Samu Kujito.
Right.
He was there.
Yes, he was there.
Okay, so we'll just watch him and listen to what he said, and then we'll come back. He will wrap up for us.
Core of the issue is that we as citizens should appreciate that the courts are there to defend the Constitution, to ensure that there is justice, and therefore we need to afford the protection that they need. But we find that the populace, the media, we go on undermining them, attacking them, attributing motives to them when they give judgment. That is the one that creates tension, particularly when we realize that the majority of the people are illiterates or semi-illiterate.
There's also a theming issue. If you actually follow the Afrobarometer clearly over the years, since 2012, it's showing a trend where public trust in the judiciary is on the decline. Is this a worry?
Yes, of course, that's very worrying. It's very worrying because of the allegations of corruption and the rest of them. And you see that...
Can this judiciary be trusted, really, to deliver the kind of justice we want in an election period when the trust for this particular institution is waning?
I do not see why not. I do not see why not. That's the more reason why I say many of us who have opportunities to interact with them, try to urge them on, to encourage them to be bold.
For Joy News, Raymond Akwa's report.
And Raymond Akwa did those honors there. But it was an event in which you presented a paper too. Now, for the legal luminaries and the political parties and their representatives and the various justices of the court who were present, did you get that very consensus from them based on what their responses were, that we could translate what the conversation there was to the mainstream issues? Because we know that when the elections happen and the things that happen with it, it becomes more rancorous in many respects.
The conversation is reduced into a report on recommendations for how to ensure speedy adjudication of election-related cases. And when I say election-related cases, it is for a good reason. For now, those that are coming up, you call them election-related cases. After the election, if people are challenging the validity of their results or the election of somebody, you call that an election petition. So there is a report, and the report contains the recommendations, and the Chief Justice signs off on them as the clear orders by which the game ought to be played in her courts. These are her courts. So you have no option. That's what you ought to do. In fact, looking forward and beyond even 2016, part of my recommendation in the presentation I did was that we should be able to take a learning from the Kenyan experience. In Kenya, the presidential election petition, there is a provision in the constitution and in the rules. In Ghana, we have provisions in our constitution and in what we call the rules, which is the CI 74. Now, in our rules, it provides for filing the petition, presidential election petition, within 21 days. After you have filed, the parties you have served, if it is the president who has been re-elected or something, and the EC, they have 10 days within which to reply. After that, within 15 days, the hearing is supposed to start. When the hearing is complete, the judges have within 15 days to give their judgment. What I find to be a lacuna, what I find to be a loophole, which may need fixing, is that the period for the hearing is not time bound. So we did 8 months. In Kenya, the period for the hearing is 14 days. So they use 14 days and dealt with their presidential election petition.
Everything in there.
They were finished. So I made the proposal that it ought to be possible that for parliamentary election petitions, we should limit ourselves to a maximum of 30 days. 30 days to deal with it, not beyond 30 days. Then for presidential election petitions, we should deal with them within 80 days, maximum 80 days. We don't go beyond that. And whilst we are doing that, there should not be a swearing in for the challenged individual. Whether you are MP challenged or a president-elect challenged, there should not be swearing in for you. Because you see, when there's a swearing in for you, then we still give room for tensions to rise.
So who takes charge then, the Chief Justice?
That's what that means, is that I said that is for going forward. It means there's a need for tweaking of the Constitution to the effect that there should not be a requirement for us to have a president sworn in by the 7th of January. So when that happens, it means that we'll put in the Constitution that when there is an election challenge, someone will act, and we will say who should act.
And you didn't recommend?
I don't want to recommend who should act.
Right.
Okay. Now, Dr. Bimpombuta also mentioned one issue, which is very important, which needs change. In the representation of the people's law, where when you commit electoral offenses, that's the law you are supposed to be used to deal with you. When the police arrest you for committing any offense like snatching a ballot box or doing any of the untoward things or prohibited things at the polls, the police is supposed to get express written permission from the Attorney General before they can go on and prosecute. That's according to Section 42 of the law. If they don't get that, they can't prosecute. Can you imagine how that situation makes it difficult? So that the Attorney General belongs to a government, right? Belongs to a party sometimes. If this Attorney General is supposed to take this action, and this involves members of the party that she has, sympathy to, there may be a difficulty. She may want to do her job, but the president may have an influence on her. The party may have an influence on her. I'm not saying that is actual. It is up to us to determine whether it is real or it is not. So, Dr. Bimpombuta said, we need to change that law also. Actually, one of the proposals came from the Chief Justice also, that we need to amend that law also, so that they can go ahead without the need for express written permission from the Attorney General. The police who were there said, well, we can go ahead and charge the people under the criminal law rather than the election law, because the crimes they commit, you find it in the criminal law, and you find it also in the election law. But that's a big challenge. This is the big challenge. Kofi Juma recently was involved in electoral offense. He was charged under the criminal law. He got a small fine. He paid it. He's gone. If he had been charged under the electoral laws, do you know what would have happened to him? He would not only be fined, he could have gone to jail, but in addition to that, he would have been banned from voting for 5 years. He would have been banned from being registered to vote for 5 years. He would have been banned from holding elective office. That is deterrent enough. And we need to tweak all of these things to allow for...
I love that one. That's deterrent
to discourage the violence that occurs.
Sounds like more deterrent.
Yes.
Than
yes.
usual. Thank you very
more
much.
Importantly, the resort to ADR is also good.
Okay, we'll see
Right.
whether the parties really will be willing to resort to ADR. That is, if they are asked
They
by
have
the,
to. If they have
by
Ghana
justice
at
of the
heart,
court.
they have to.
All right, Samson Ladia, he has to go on outside this very building to do his work, and so we'll have to make him leave. But we have to take a break, and then when we come back, we'll have a lot more for you. Thanks for joining.